It's my great pleasure to introduce Alexandra Lahav, who is the Ellen Ash Peters Professor of Law at the University of Connecticut School of Law. She's also one of my former colleagues, so I'm particularly delighted to welcome here today to talk about her book, In Praise of Litigation. And joining her on the panel are the Eli Goldston Professor of Law, John Goldberg, and the William Nelson Cromwell Professor of Law, Mark Tushnet. So I'll turn it over to you.
So first of all, thank you so much. This is wonderful. It's really an honor to be back here, and it's really quite joyful to see so many familiar faces. So thanks so much for coming out. I'm just going to give a short overview of the book, and then we'll hear from Professor Goldberg and Tushnet. So I want to start with two stories. One is a tort story, and one is a civil rights story. So in 1996, in the West Coast, there was a juice maker called Odwalla Juice that you may have actually heard of. In that incarnation, Odwalla sold unpasteurized juice, so it was all natural, was the selling point. And some of the juice they sold was apple juice, which is a very popular drink among children. And what happened was that their juice was contaminated with a bacteria called E. coli. In November of 1996, there was a massive E. coli outbreak as a result of this juice in Washington State, Oregon, I think California, and several children died of exposure to this bacteria. The company was sued by a lawyer named Bill Marler, who still practices out of Seattle, on behalf of the families of the children who had died and some of the children who had suffered disabilities as a result of their exposure to this bacteria. And in the course of that lawsuit, Odwalla disclaimed responsibility. They said, we're sad about the tragedy and we're happy to pay your medical bills, but really this is not a situation of case of fault. And it turned out that Bill Marler got a call on his voicemail one day that said, you should file a FOIA request with the United States military about Odwalla. And he did, and that FOIA request revealed a letter that the Army had sent to Odwalla in June of that year, so months before the outbreak. And in that letter, the Army informed the juice manufacturer that after inspecting their plant, they did not want to purchase Odwalla juice for their commissaries because the plant was too unsanitary. In other words, what they were telling Odwalla was, your juice is not safe enough for soldiers to drink. But Odwalla continued to market the juice to children over the following months, and ultimately it resulted in a multi-million-dollar settlement for the children. Of course, one of the themes of the book is a litigation and a settlement can't undo the tragedy of the children who are permanently disabled by being exposed to this juice, right? But what it can do is change behavior going forward and provide some accountability. And I'll talk about those things in a moment. The second case is called Casal against Kelly, and this is a case that was brought in New York City in the early 2000s. So in the late 1990s or early 2000s, the Second Circuit held, as every other circuit has done, that loitering for the purpose of panhandling is a First Amendment protected activity. And what the New York City Police Department was doing as part of sort of a larger policing scheme was arresting homeless people who were standing on the street. Some of them were panhandling, some of them were just standing. The homeless people brought a class action against the city of New York, alleging that the city of New York was violating their First Amendment rights, as had been established by Second Circuit precedent some years earlier. Ultimately, the homeless people won that lawsuit, but it took about 10 years for the NYPD to stop arresting homeless people under that loitering law, which was unconstitutional. So it wasn't a magic bullet. It took a long time and protracted litigation and finally a contempt order against the city to resolve that suit. So those are my two stories, and now I'd like to tell you a little bit about how they illustrate the values of litigation and the difficulties with litigation. So Casale illustrates a basic concept that litigation is about. And the way I like to think about it is the coinage that Hannah Arendt gave, which was this idea of the right to have rights. If you have no access to the court system and you're otherwise a disempowered person, like a homeless person in the city of New York, your vote is not important to Mayor Giuliani, then what's left to you is access to the court system. None of the people in New York, the other people, that is, who weren't homeless, cared about what was happening to this group of people very much. There was no political movement around it. So in order to have any access to their own constitutional rights, they needed first to be recognized by a court as a group that was entitled to have a right. And that meant access to the court system. The problem with this conception is that in the United States, there's a very, as you know better than me, there's a severe inequality of resources. The other problem with being a homeless person is that you have no time and you have no resources. You're not a person who can fund a lawsuit. So that lawsuit was funded through a fee-shifting mechanism that was instituted in the 60s that permits plaintiffs who prevail to get their attorney's fees paid. So the Casale plaintiffs were able to get very good representation to bring their claim. Representation that was lawyers that were willing to pursue their claim for years, right, because they were enabled by fee shifting. And what does that tell us? It tells us that in order for you to have the right to have rights, that is, in order for you to access that neutral decision maker who's a government agent who will enforce your rights, you need to have some modicum of equality between the litigants. And that sometimes means material equality, that is, the attorney's fees being paid. And it also means social equality. That is, you need the judge to be willing to recognize this group of people as a group of people that's entitled to equal treatment and to equal enforcement of the law. Even if maybe the judge isn't that happy, the judge lives in New York, maybe they're not that happy that homeless people are loitering on the streets, right? But the question is, can they give that litigant equal concern and respect? These principles are now being severely eroded by both the attitude of judges and rulings from the Supreme Court on down that really strive to limit people's access to the court system. The justification for it is largely cost, that it's too expensive to defend lawsuits, that too many people bring non-meritorious lawsuits. And what's forgotten are these other important democratic values that are part of what makes our system work and what should make us proud of our system. And we should at least account for those as part of our cost-benefit analysis as we're thinking about legal reforms, which are actually currently in Congress right now. There's a whole spate of legal reforms aimed at shutting access to the court system that's going to be voted on by the Senate at some point in the next few months. On to the two other principles. So that was the idea of the right to have rights or participation in our own self-government and equal treatment before the law. Two other important democratic principles are promoted by litigation, and these are information forcing or transparency and enforcement of the law. So the information point is pretty clear. We wouldn't know the story of Adwala if Bill Marler hadn't brought that lawsuit. But more than that, over and over you see institutions using information that they gain from lawsuits, as well as regulators using information that only comes out because somebody sued in order to change the law and to alter regulations. Bill Marler today is hired by companies who want to avoid litigation, and they hire him in order to look at their systems of how they keep food clean and safe, and to give them advice on how they can improve those systems so that they won't contaminate the food that they serve to customers. Finally, enforcement. And here I split enforcement up into three different ideas. The first is the idea of answerability. And this relates to the right to have rights. This is the idea that what litigation does is it forces the other side to come forward and answer for what you say they've done wrong by you. And this is a really important social moment when your opponent, be they a large corporation, the government, or even your neighbor, has to come and explain why it is that they did what they did. That's answerability. Now, sometimes a lawsuit will end with answerability. That is, the defendant comes forward and says, look, I didn't do anything wrong. Here's all my proofs. This conversation is basically over, right? But sometimes it goes a step further to accountability. That's what you get in settlements when a defendant pays a plaintiff a settlement. And it's what you get with injunctions when the court enjoins the city of New York from arresting homeless people without a basis in law. And finally, there's the idea of deterrence, which is a big part of enforcement, right? That other people look at the Odwalla story and say, I'm really going to think twice before I start to market unpasteurized juice without being really careful about how my facilities are structured so that I don't distribute a contaminated juice that's going to result in this kind of tragedy. So those are the three things. I just want to say a word about why I wrote the book. So I was actually looking for a book that made these arguments so that I could assign it to my students. And I kept looking for it, and there's some books that kind of talk about how the tort system is really great and does all these wonderful things. But there wasn't a book about litigation generally. And when I teach procedure, I want to teach about a bunch of different cases, not just torts. And so I was a little bit stuck. And I was wondering, well, why don't we have this argument? I mean, you see it in pieces in academia. There'll be an article here, an article there that takes part of this argument. But it's never kind of put together as a whole argument. And I think the reason is that in the realm of ideas, the cost story is the dominant story. It's the story that's prevailed. And there needs to be a counter argument out there, and this is what I hope this book will do, without denigrating the idea that there are costs associated with the social institution. That is, this is not a cost-free thing. It's not a walk in the park for the people who are participating in it. But that doesn't make it less important. It just means that we need to weigh these other values. And I think even the harshest proponents of a cost-cutting regime might be open to these kind of democratic arguments. And the reason is that ultimately, in a society where you don't have access to the court system to vindicate your rights, the alternative is very ugly. And we don't want to, I think, live in that kind of alternative. So in order to have a civilized society, you really need for people to feel that they have this access to a neutral governmental officer who will evaluate their claims separate from the executive, separate from the Congress, and separate from the institution about whom they're complaining, that can hear their story. And in other societies, if you study societies that don't have robust legal systems and don't have the rule of law, ultimately the resort is to violence. So that's an extreme thing that can happen. But as we erode our court system more and more, which is what we've been doing basically in my lifetime, that's in the end what we face, is for people to feel that they have no recourse and there's nowhere for them to explain what was the wrong thing that was done to them or to make their arguments. So that's my story, and I look forward to your comments.
Thanks very much. So this is an excellent book. You should buy it. It's wide-ranging in just the way that Professor Lahav described, and it's admirably accessible, which is a rare quality for any book written by a law professor. And most importantly, it's a welcome counterweight to the currently dominant narrative. According to that narrative, we have a litigation system that is out of control and that delivers arbitrary jackpot justice. Implicit is the thought that litigation is something that needs to be drastically curtailed. Now, you have to appreciate Professor Lahav has not given herself an easy assignment. Indeed, I look forward to her next book, In Praise of the Department of Motor Vehicles. To see the difficulty, one must focus on the object of her praise. It would be one thing to write a book titled In Praise of Liability, but that is not this book, as another vehicle-related analogy can help us see. As you all know, the Massachusetts Turnpike is now a toll road without toll booths. Instead, electronic equipment detects your car's transponder, or more creepily takes a photo of your license plate and generates a bill that shows up in your house. This same technology, I would imagine, could be employed to generate automatic citations and fines for every instance of speeding on the Mass Pike. One presumes it has not been so deployed purely for political rather than technological reasons, as state officials presumably want to keep their jobs. Imagine fantastically that we had comparable technology to address not just speeding, but all manner of wrongdoing, consumer fraud, civil rights violations, breach of contract, etc. Wouldn't this vastly more efficient mode of law enforcement, one that spares us from complaints, answers, motions, multiple rounds of discovery, monstrously expensive jury trials, endlessly appeals, and let's face it, lawyers, wouldn't that clearly, from society's perspective, be an improvement? Well, I'm not sure that Professor Lahav directly answers this question. It wasn't her question. But I am supposing, and she will tell me if I'm wrong, that her answer would be a resounding maybe. And this is interesting because many would reflexively suppose that the answer to my hypothetical question would be a resounding yes. The reason for these different responses is because Professor Lahav does not regard the process of litigation as a deadweight loss. Rather, she claims that it provides important goods even beyond the obvious good of creating a need for civil procedure professors and torts professors. In particular, along with law enforcement, there are the goods of transparency and participation, and relatedly, the good of providing a forum in which the powerless and powerful interact on equal footing, at least in some respects. Thus, before shifting to an imagined world of automatic enforcement, we would need to consider carefully all that would be lost when litigation disappears, including the discovery process and the empowerment of ordinary citizens, both in their capacity as claimants and jurors. This is how she gets to maybe, as I understand it. Now, I think Professor Lahav is quite right in many of her basic claims, and I think she's right not just as a matter of abstract policy. I think many of her arguments and many of the values she identifies are deeply rooted in our constitutional traditions. You can go back and find opinions where, believe it or not, the United States Supreme Court said things like the following: each state has a duty to provide law for the redress of wrongs. They said that in 1880. I don't think they've said it since. So I think she's very much onto something, and as I say, I think the book is really successful in that regard. But of course, I have to be difficult, so I'm going to conclude by raising a question that comes out of some of my own thinking about tort law, unsurprisingly. The question concerns how the different goods or values of litigation relate to one another and whether they conflict to a greater degree than Professor Lahav perhaps allows. Now, as she notes, one could argue that to the extent there is a litigation crisis, it is a crisis of under-litigation rather than over-litigation. Admittedly, the data is patchy, but there's some evidence that many persons who have valid claims, contract, tort, whatever, never bother to sue. Moreover, even when suits are brought, they are often settled on the cheap in amounts that reflect, for example, the limits of liability insurance coverage rather than a plausible estimate of the actual harm suffered. For those who see civil liability as primarily a system of deterrence, where's Bargill? There he is. This data suggests a big problem, under deterrence. So too for those who see torts as primarily a compensation system, under compensation. And so too for Professor Lahav, as under litigation generates not only a deterrence and compensation deficit, but transparency, participation, and accountability deficits as well. But is under litigation necessarily a bad thing? Well, if one views litigation from a social or aggregate perspective, what goods litigation stands to deliver to society, then it seems like it has to be. A different perspective, however, holds that litigation in an area such as torts or contracts is something that is made available to persons who choose to vindicate their rights as against those who have wronged them. If that's how we view litigation, as first and foremost empowering victims, then one cannot infer from the failure of litigants to bring winnable lawsuits or from settlement on the cheap that the system is performing badly. It might be, But before we reach that conclusion, we need to know a lot more about why suits aren't being brought or why cases are settled on the terms on which they are settled. There's plenty of reason to believe, and it's covered very nicely in the book, that many suits are not brought, and many low-value settlements are made for the wrong reasons, whether in the form of ill-advised procedural hurdles or the unavailability of counsel to low-value claimants. But there's probably some reason to think that many litigants refrain from suing or agree to modest settlements because that's what they want to do. Not everyone who is the victim of malpractice wants to sue her doctor. The same is true for employees subject to workplace race or gender discrimination, and so on. Insofar as we have under litigation for good reasons, and again, this is partly an empirical question, I would argue that the litigation system is working just as it should, irrespective of any losses in terms of transparency, participation, and equality before the law. And in this respect, there is a deep tension between an understanding of litigation as a system of victim empowerment and an understanding of litigation as a deliverer of other social goods, such as participation and deterrence. To be clear, Professor Lahav at times acknowledges this tension, as in her discussion of confidential settlements that deprive the public of important safety information. Still, I worry that her excellent book perhaps gives insufficient weight to litigation's empowerment dimension and therefore understates this tension. Thank you.
Professor Goldberg talked mostly about the torts kinds of problem that Professor Lahav introduced in her introduction, and I'm going to talk about the civil rights part of it, and focus on the chapter dealing with participation, litigation as a vehicle for participation. I'm start with an anecdote, historical anecdote, about how litigation had in the past been a vehicle for a certain kind of public participation. As it happens, this is a criminal case that I have the clearest example on, but I'm going to describe something that happened quite frequently. So in the early 1940s, Thurgood Marshall was the chief lawyer for the National Association for the Advancement of Colored People, and he went to Oklahoma to defend a criminal trial. And the part of the story that is important here is that the schools for black kids in Oklahoma, in the area, basically let the kids out during the trial so that they could attend the trial. And there's a number of letters saying one of the most important things that happened was that the kids saw a black lawyer arguing on equal terms to the white lawyer who was prosecuting. And that's an important participatory value from having an open trial. There are, as I say, similar examples in civil cases as well. I want to now bring the story down to the present with some more, I don't quite know what the right word is, skeptical examples. And these are drawn from my observation of my wife's experience as a litigator for prisoners' rights. And there are two aspects of it that I want to focus on. One is something that Professor Lahav mentioned, which is the sheer length of litigation, which undermines, at least weakens, the participatory value of the litigation. So two examples. My wife litigated a case about conditions at the Maine prison in Michigan, Jackson, Michigan. That case began in 1982, I believe, when the U.S. Civil Rights Division under Ronald Reagan and William Bradford Reynolds proposed to enter a consent decree with the Michigan system, and my wife, representing prisoners, intervened in it's 1982 on the ground that this was a sweetheart deal and wasn't going to do anything. And that lawsuit lasted for 32 years before it was terminated with a decree in, I think, 2014. There's still some echoes of it going on. Last year, she went to trial in a damage case for a prisoner who had been a member of the class, and she's now working on a similar case for the estate of a member of the class who I actually think she met when he was still in prison. So that's 31 years and still going. 2 years ago, she got involved in the filing of a lawsuit against a prison in Mississippi. This lawsuit will outlive her. There's just no question about it. It may go to trial over this summer, but probably not. And that's 2 years on, and so on. So the extent to which these things can be vehicles for a form of public participation other than as the place where prisoners can get some redress, somebody in some sense to listen to them, although the them part is something I'm going to come back to in just a moment. So it's participation for prisoners who can't participate effectively in other venues. This is why this is the point about homeless people and Mayor Giuliani. Prisoners in Eastern Mississippi facility not going to get a sympathetic hearing from the Mississippi legislature. But they're also not going to actually, in some important sense, be in court. As I was preparing for this, I opened the book and literally opened it to the page that begins with the quotation, "I never saw a single plaintiff appear before me." And that's true of my wife's clients. Now, a couple of things are sort of structurally built into this. So she's represented clients in connection with the Baltimore jail, the Freddie Gray institution. And people in jail aren't there for very long. They circulate in and out. So it's not surprising that you don't see the plaintiffs. But in some sense, more important, if you unpack the process, the plaintiffs are there, but very much in the background. So I would be surprised in the Mississippi case whether there would be testimony, in-person testimony by a single plaintiff. What happens is that there are interrogatories, and incidentally, in the Mississippi case, the interrogatories from the defendants to the plaintiff class, plaintiffs had to be protected by a protective order because the place was so dangerous that if the defendants knew who the plaintiffs were, the plaintiffs would be at serious risk of physical injury. A lot of the material in the case is about medical care, and so that is done through the production of medical records. A footnote here, one important reason why the case focuses in important ways on medical care is that in 1996, Congress passed something called the Prison Litigation Reform Act, which in this dimension caps attorneys' fees. And so it becomes harder to finance these lawsuits. My wife actually devised the strategy around the fee cap, which is to file claims under the Americans with Disability Act, where the fee is not capped. And so the medical care becomes an ADA lawsuit. But the medical records are, they're paper. And then finally, most of this lawsuit is about experts. There are experts who go in and look at the facilities and describe the medical conditions and in Mississippi, the heat during the summer. In Michigan, it's the cold during the winter. which are life-threatening. People die. There are death records at the Baltimore jail attributable to both overheating and lack of heat during the winter. And in all of this, the named plaintiffs really recede from view. They are virtually represented. I've no doubt that the members of the class are happy about the lawsuits being brought, but it's not easy to describe them in participatory terms. That's not to say that this kind of litigation doesn't have other kinds of participatory values, and of course, not to say that it doesn't have other values. But in the chapter on participation, Professor Lahav talks about the ways in which, in some of these cases, the plaintiffs/victims actually come in and testify and tell their stories. That's rare in the kind of litigation my wife does. And it seems to me a full picture of participation as a value for litigation probably has to take these sorts of qualifications into account.
So I'll just respond, and then maybe we could take questions if people have questions. In a way, both the comments are about autonomy values, that is, the participation conceived of as an autonomous ability to come and tell your specific story directly to the judge. The victim empowerment theory of litigation as an autonomous choice on the part of the litigant whether to participate or not. And in fact, one of the strongest and most powerful arguments against the class action device in general is the autonomy argument, which has come to the fore most recently as an argument that I have a property right to my claim, which they call a chose in action, and that by somebody else dispensing with that right, for me, they've stepped on my either autonomy rights or property rights conceived of in an autonomy kind of shell, like a delicious autonomy M&M with a core of property in the middle. And so I think the autonomy issue is a major issue for modern litigation. That is, in the 21st century, as in the 20th century, we live in a mass production society. We live in a mass incarceration society where it's very, very hard to do things on a bespoke individual level. And the challenge, which I try to explain in the book, is how do you promote participation in a way that also is true to some other values like equality, both equality of treatment as between litigants so that I get the same treatment as somebody else who suffered the same wrong as I did, and also equality between the litigant and their opponent. That is, if the opponent is the state, it's going to be very difficult for an individual self-funded to maintain that litigation. And I think Professor Tushnet points to a very serious problem for participation. The way I would like to spin it is that your critique, I think, is a descriptive one. That is, it is difficult in these types of litigations to maintain a client connection. Sometimes those problems are, as you describe, problems where we have actual danger to the class members. Other times, it's lawyer callousness. That is, the lawyers are satisfied to keep the class members outside of the litigation, not to consult them, not to bring them in. So the quote that you read, it was Judge Weinstein speaking about the Zyprexa lawsuit. That was a lawyer choice not to bring in any Zyprexa plaintiffs. They could have brought them into the court for hearings, and they chose not to do so. And the reason is it's a lot of trouble, and it's not necessary. I put that in quotes, right? And so the question is it necessary? So I try to argue in the book that we should try to both reconceive the idea of participation a little bit away from this autonomy view, but also create new ways in which people can participate. I think that the greatest challenge to the legal system since, or to litigation rather, since I guess the 60s has been institutional reform litigation and the problems that are raised by institutional reform litigation, which I think Professor Tushnet aptly described. What I want to do in the book is that conversation has been largely about court power, the limits of court power, the shape of court power. What I want to do in the book is shift that conversation a little bit to the litigants themselves and to try to look at, well, what's their role in this? What should their role in this be? How can we give them a more robust role in the situation you describe? I think, it's hard for me sitting here at this moment to imagine the solution to the problem. But I think once you identify it as a problem and you say, this is a problem that we need a reform of the procedural system to find a solution for it, how are we going to do that? And can we step away from a vision of procedure or litigation as, and in the end, I will have a trial and I will sit on the stand and somebody will question me. And that's what litigation is idealistically about. If we can step away from that and find some new kinds of procedures, some of which I describe in the book, I think it would be an interesting conversation to have. But that's the kind of conversation that we should be having rather than sort of revisiting the same old questions, which really are not, it's just not realistic to have a conversation about how are we going to make sure every single person gets their own trial. We're not going to make sure that it's not going to happen. So what other ways can we promote participation and dialogue and bring attention to problems that aren't, that don't look like that? And I have some suggestions. I'm happy to talk about them in the Q&A.
Should we forbid confidential settlements on the grounds that the informational value of the litigation is compromised if you can hide the amount of payment? And the second is, should we permit sales of shares in lawsuits on the grounds that not only does it potentially overcome the lack of financial resources of plaintiffs, but also shields them to some extent against the emotional cost, which seems sufficiently severe that it helps to explain the troubling frequency with which cases are settled for low amounts. Not just financial difficulty, it's just really painful to litigate.
So, I can turn this off during the question and answer. So I would say one thing I like about your questions is that they point out that litigation is very costly, not just to the defendant, but also to the plaintiff in many cases, especially in tort cases. That if you put yourself out there and you sue, then the defendant is entitled to get all kinds of information about you and to use that against you and to depose you. And all those things can be very painful experiences, and that needs to be recognized in the calculus. I personally think that we probably should forbid confidential settlements. My view is that if you are taking part in a public system that we all pay for, then we're all entitled to know the outcome of that. I think there are worries about certain aspects of confidential settlements. So for example, there are situations where somebody wins a large settlement and then everybody knows about it and all their family comes and harasses them. And there are all sorts of issues that can arise that don't have to do with sort of public promoting function. And one really fabulous suggestion that Steve Yezel made a number of years ago was to have, he called it a NASDAQ for lawsuits, so that you would redact some identifying information, but you would reveal in the run of cases what cases are settling for. There are specific instances, like the instance with sexual abuse in the Catholic Church. Another example I use in the book is Ford Firestone Tires, where litigants are specifically trying to hide ongoing dangers to similarly situated persons through the use of secret settlements. Some states have sunshine laws that forbid that. Other states don't. There's a big dispute about it. And it really bottoms on this distinction that I talk about in the book, which is between the litigation as a system of dispute resolution, in which case secret settlements are fine, And litigation is a system of information and law production, in which case secret settlements are a really bad idea, except under very careful circumstances where the judge actually looks at it. But treating them as an ordinary contract, which is how they are mostly done now, I think is a huge mistake. As for sales of shares in lawsuits, is a very popular subject of conversation among proceduralists. The original, I think, bar on, and you'll correct me about the pronunciation, Champerty, there you go, I knew I would get it wrong, was that if the litigant needs to be involved in the lawsuit on an ongoing matter, so for example, there's a tort suit and I'm the victim, I'm going to need to testify, I'm going to need to submit to medical examination. It creates all kinds of screwed up incentives for me if I have sold my claim to someone, to a third party. And it also creates bad incentives for that third party as well, to force me to do things. This goes back to the autonomy question, to force me to do things that I don't want to do. So in the tort space, I would say that it is, I think those arguments are very powerful. In consumer law or other kinds of, like what you might call depersonalized claims that have to do with business transactions, it seems to me that those claims don't really matter very much. That is, if I'm in a dispute with my credit card company, I'm not really worried about, how this is going to affect me on an individual level when they depose me in the same way, or that they're going to need my mental health records or something like that. And so I think it would be more, but they get around this prohibition in other ways now through litigation financing and loans. So for every rule that you think is a rule, there actually is, it turns out, a business workaround for it.
First of all, thanks a lot. This is very interesting, and I take and agree with almost everything that has been said. I have a couple of questions, and they're focusing more on the tort side than on the civil rights side. And so the question is, when we're talking about the praise of litigation, and litigation as an institution, what are we comparing it to? So are we comparing it to nothing? Or maybe we are comparing it to other alternatives that might be somewhat protective, maybe in a different way, maybe not as good, maybe better in some ways, that might be protective of individuals' kind of interests in kind of compensation and deterrence and so forth. And so what I have in mind is kind of regulation on the one hand and arbitration on the other hand. And so I could imagine that at least some of these interests would be protected by effective regulatory interventions by, say, the Federal Trade Commission or the Consumer Financial Protection Bureau. And they kind of protect the interests of these consumers. They provide restitution. In some cases, maybe there's even some kind of room for kind of voice and participation. So that is kind of one comparator. So when is litigation important or much better than this alternative? That's one. And the second would be referring to arbitration. I'm not talking about the arbitration as an excuse for no action, like in class barring arbitration when the purpose is clearly just to avoid anything. I'm talking about maybe an idyllic form of arbitration, which doesn't have to be secret, which can be, the information and transparency can be served when the arbitrators are maybe are not biased. And then at the end of the day, just serves to kind of maybe address Professor Tushnet referred to as kind of a 30, 40-year litigation just because of the various limitations of the system.
The compared to what question is a great question, and you actually raised it in your comments with if we had an ideal world where every wrong could be immediately identified and righted, wouldn't we be satisfied? Why would we want litigation? I was thinking of a response to that, and what I think is that the problem is we don't actually agree on the wrong. So part of what litigation does is it allows us to fight about what we think is right and what we think is wrong. So if we lived in a world where we all agreed about exactly what laws ought to be enforced and in what way, then I think that would be super. I would definitely sign up for that world. That is not the world that I live in, and I don't see that I will come close to living in that world in the near future, and so that's sort of a little bit of the realism of it. But I'm signing up for it in theory. I think, there's that nice little book by Stuart Hampshire, Justice as Conflict, and it's, it has its flaws, but one of the things that it discusses, and there's some other democratic theorists that talk about this, is the importance of contestability. That we need to be able to contest principles as well as policies. This is a way to do that. So that brings me to Professor Bargill's question. In many cases, I think that if we had a strong regulatory state, that would be a preferable institution for resolving many of these issues. That is, if you said to me, you can have a choice between the Odwalla litigation or ex ante regulation where nobody dies of E. coli poisoning, I would pick option B in that case, right? The problem is that we have a very weak regulatory state in the United States, and that historically what we've done, and there's some great literature on this if people are interested, is because for political reasons, we've shifted regulatory enforcement to the private sector. So instead of having a very powerful EEOC, we have discrimination laws that do a lot of that work. And that's why we have fee-shifting regimes and all of this extra complexity. In the book, I don't talk about that comparative institutionalism. That is, would it be better to have a really strong EEOC instead of anti-discrimination laws that enable individual lawsuits? There's a lot of people have written on that, and I think it's very interesting. And I personally would pick the more regulatory side of that question. But I think that the problem is what we're seeing now, what's happening, is that we're shortchanging litigation without providing any institutional alternative to achieve any of these goals. That is participation, equality, enforcement of the law, or information. What we're doing is eliminating the ability to bring a lawsuit using procedures without undoing any of the substantive rights. So on paper, if you look at it, it looks like you have the same rights. But in fact, you can't realize them because the only way that the law enables you to realize them is by bringing a lawsuit. And there are all of these ways in which you're going to be prevented from bringing that lawsuit, or they're going to make it so costly that when you do the analysis, you'll realize it's a terrible idea, or no lawyer will take it, which is more often what happens. And that's the risk, is that I think in our society, people really aren't willing to give up a right that's on the books that's been granted. So I don't think we'll see, for example, a rollback of the 64 Act. But we have seen a rollback of people's ability to enforce their rights. And it's the same thing with constitutional law and prisoners. So you have all these rights, but you can't enforce them because the PLRA, which is impossible to understand, is going to prevent you from doing it through a million different methods. And that's really the risk, I think, is that within the institutional constraints that we have, this is the way the politics is moving. But I think you could do a really interesting comparative institutional study and invent new institutions that could achieve many of these goals. And I've sort of thought about doing that, but I think it might be too boring to read for many people.
I had a question about something you said at the beginning, which is that you'd like to, you know that the cost story is what a lot of people talk about. You'd like to put something on the other side. And I'm curious how you think we might develop our intuitions about how much these values are worth compared to each other, compared to money, and if we can do that ourselves, how we might talk about it and discuss it, agree with other people. I remember you assigned a case, I think, where a student gets suspended from school without due process and gets $1 for it. It sounds outrageous, but sort of at the end, you might sympathize with the judge and say, you don't really know how much it's worth. I at least personally find that I sort of more often end up in a place where I'm less certain of how much this is worth and how much that should be weighed, rather than a position which I can say, yes, we should do this and that, unless the case is very extreme. So I wonder how you think we might go about refining our ideas about how to weigh the things.
Yeah, that's a very hard question. I think it's balancing. Balancing is, I feel like, rather out of favor these days as a method of, methodology for thinking about things. But I think sometimes the values that I talk about conflict with one another. So for example, you might be able to more quickly enforce a law by settling when in the process of doing so, you're not going to reveal as much information, or you won't have as much participation, so that they can conflict with one another. And I think what the strength of the courts is thinking through these issues in an individual case and trying to balance them within that case. I think for legislatures, the challenge is more along the lines of what you're talking about, that is thinking more abstractly about, how much cost am I willing to incur to let people participate? How many more judges am I willing to hire to let people participate, or to require that information be revealed? When I look at the data on discovery, it's so shockingly not expensive that this myth that discovery is outrageously expensive. I mean, it's spurred by cases like Apple and Samsung, my personal favorite, which costs $1 billion to litigate, and that is a lot of money. It's also, at the time, it was 2 weeks of iPhone sales, right? So it's a lot of it is about understanding things in context. But I don't have a good answer for you, other than to say I would like to have that discussion and to start talking about it on those terms and trying to do that balancing, rather than just saying, look, I have discovery in this case and it's going to cost $20,000. That's a lot of money. We should not allow it, right? It's like, well, what information are you going to get? How is that relevant to the public? What is the wrong that you're talking about? Those asking those kind of questions, which really doesn't seem to happen, at least from, I read all the Rules Committee discussions. I read and watch the congressional hearings on these things. These are non-issues for the people who are in the decision-making world. They're really looking at how much is this going to cost, and if it costs too much by a measure that I don't personally understand where it's coming from, then we don't want to do it. And that is an interesting and sad state of affairs, I think.
My apologies, I have to go teach.
Do you ever see, can you hear this microphone? Do you ever see instances where litigation exacerbates inequality? And I'm thinking of if state or federal government threatens a lawsuit against either a private business or an individual, the state or the federal government has such deep pockets and such access to publicity that the defendant settles when really a settlement is not called for.
Yeah, I mean, those are situations that occur. I have a nice story about something like that. So there was I guess it still goes on, though Professor Bargill will tell us if this still goes on, but my understanding is that with respect to consumer debt, sometimes the people who own the debt, I guess the credit card company or whatever it is, will have like Excel spreadsheets of everybody's name and information and how much they owe, and they will sell these to venture capitalists or groups of business people. And there was one law firm that entered into a business relationship with one of these venture capital firms. And what they did was they would robo-sign complaints, so they would sign like hundreds of complaints a day. And in New York, in order to sign a complaint, it has to be what's called a verified complaint, which means that the lawyer is verifying that the facts in the complaint are true to their knowledge. But the lawyers in this case had no knowledge of whether the statement that the debt that they had purchased for pennies on the dollar was in fact the debt that the people owed. So what they did was they mass filed these complaints, and then they sent them to a service company that would provide service to the plaintiffs. And the allegation was that they'd engage in what's called sewer service, which is exactly what it sounds like. And ultimately, they would get default judgments, and then once you have a judgment, then you have power. And so they would enforce the default judgment by garnishing people's wages or doing other things that a judgment entitles you to do. But in many cases, the person did not owe the debt. That is, there was an initial mistake in the Excel file that had been purchased, and the underlying contract between the creditor and the venture capitalist was such that the creditor disclaimed any accuracy. That is, they said, here, I'm giving you these things. They may be true, they may not be true. I don't know. I'm not making any warranties about that, right? So people came forward. They're saying, well, GAAP says I owe $3,000, but I don't. They've made some mistake, and now there's a default judgment against me, and they're garnishing my wages for that amount of money. What can I do? And so a firm brought a class action. So you have a second law firm bringing a class action against the first law firm saying, you violated all these people's due process rights by not looking before you leapt, basically. After some significant amount of time in litigation, that class action was certified. But a judge on the Second Circuit wrote a vitriolic dissent. And he said the dissent was aimed at the class action lawyers. And he said, you guys are just hungry lawyers looking to take advantage of every plaintiff. And there's no purpose to bringing this lawsuit. It can all be addressed in some administrative proceeding, apropos Professor Bargill's suggestion. There's some administrative proceeding that you can use in the state of New York. But of course, if you use that administrative proceeding, there's nothing to stop this firm from going and doing the same thing again. That is, it doesn't cost them anything because they're just robo-signing the complaints. It's $25 a pop or whatever it is. It's not very much. And that, to me, illustrates that both the legal system can be used to harass people unjustly. That's what the first group of lawyers were doing. It can also be used to correct that wrongful conduct. The problem that you raise is the problem of merits. That is, it's very often we do not know the merits of the case. We're not in a good position to judge the merits. We sometimes hear stories of cases where the merits, it just seems all wrong. Why is this person being sued? Either the government is suing them, or you have, in the case of the venture capitalist, you have a well-financed venture capitalist suing a little guy, right? Whatever your story is, I think the problem and the risk and the cost that we take by having a system of litigation is that sometimes there'll be non-meritorious suits, and people will sometimes feel pressured. And there's some things that judges can do to try to mitigate that by deciding cases on the merits. But in the end, those pressures will exist, and they exist on both sides of the aisle. That is, those aren't just pressures that defendants experience. As Professor Fisher pointed out, there are also pressures that plaintiffs experience. And I don't have a good answer to that because I'm not omniscient, so I don't know what lawsuit is meritorious. But I do have examples of many, many lawsuits that initially seemed non-meritorious and that today are part of the constitutional canon. So that tells me that we can't just assume that we know the merits of every case without contesting it. So that would be my pitch. Thanks very much, everyone.